about immigration. By the way, if you want to talk about something else, let me know. We can talk about a bunch of stuff. Maybe you guys have questions that you're interested in that have nothing to do with immigration. We can actually talk about that as well. Okay, so last Friday, the news about DACA came out. There was a lawsuit that was pending in Texas, and the judge made a decision on Friday. The judge, I'm not going to bore you with legal stuff, but basically, at this time, we cannot send in any new DACA applications. We can renew DACAs, no problem, but no new applications can be sent in at this time. The USCIS, which is our government, has already said that they will be appealing this decision. So this may or may not be halted for long. There have been decisions before by both our government under the Trump administration, and there have been other judges' decisions before that stopped the acceptance of new forms. And even though it inconvenienced people for some time, ultimately DACA has been resilient and has always made it through. In overwhelming numbers, the people who live in the United States support the basic idea of DACA and actually want to go beyond it, saying that if a kid was brought here as a child and this is his home country and the person has gone to college, gone to high school, is a contributing member of a society, not breaking any laws, that person deserves the ability to stay here. So I hope, as I have been saying before, that the judge's decision is going to force our esteemed members of Congress to actually pass a comprehensive solution for the DACA kids. So that's one. So for now, we cannot send in any new DACA applications, but we can continue renewing any existing DACA applications, right? So if your 2-year work permit is expiring, please, you can contact us and talk to us about it. Also, it doesn't hurt to talk to an attorney, even if you have been just renewing DACA, to see if there's anything that in your life that has changed that you can maybe possibly go forward and do something more. That's number one. Number two has to do with the tourist visas and student visas. More specifically, when you come here as a tourist, which is a non-immigrant visa, and while in the United States you have made a decision that you want to go to school here, which is another non-immigrant visa, which means at the end, non-immigrant just means that you're not going to live here permanently, that at the end of your stay, you're fully planning on going back to your home country. So you came on a tourist visa, the circumstances have led you to now want to switch over to a student visa. There is a special application that gets filed which changes one status to another status, from a tourist to become a student. Usually if you file the change of status, the change of status can be pending a few months, up to 8-9 months. We've seen it be pending, and during that whole time you're allowed to stay here and be here waiting for the decision from the immigration. The Trump administration changed that. Under the Trump administration, you had to keep extending your tourist visa to cover what's called a gap period between when your tourist stay expired and when your student visa started. You had to maintain obtained at least within the last 30 days the status. That Trump rule is now gone, and we have just gone back to the way things were before. If you're on a tourist visa and you have filed for a change of status timely, then you do not have to file any additional applications to cover any gaps in the status. So that's more of like a very technical thing. It doesn't really affect too many of our students, but for those that it does affect, makes their life a lot easier. So if you want to know more about that, Conan Tucker law.com, or give us a call and we can talk to you about that. Now, huge topic of conversation now that's going to take me more than one episode to cover, but I'll start today. Motions to reopen. Let's say you're in front of an immigration judge. Let's say you were applying for asylum, or let's say you were arrested by ICE and released on bond, or let's say you filed for a green card application that was denied and you were put into removal proceedings. You have gone through the removal proceedings and they have ended in deportation order, right? You have an order of removal from the United States. One, if you've gone through the whole hearing in front of a judge and the judge says that the judge either doesn't believe you, or you have no way of staying here in the US, or whatever you applied for you're not eligible for at the time, you have a removal order. Once you have a removal order, you have 30 days that you can appeal it to the Board of Immigration Appeals. If you had a final hearing in front of what's called a merits, or an individual hearing in front of a judge, and you just didn't go, or you missed a master hearing, which is like a kind of like a conference in front of immigration judge. If you've missed any of the hearings in front of immigration judge, there are substantial, more than 99% chances that you have a removal order. If you have a removal order because you have missed the court, then you have 180 days to file a motion to reopen in order to open up the removal proceedings and move forward with whatever your relief was. Let's go back to, you've gone through the entire hearing, and for a myriad of reasons the judge has denied your case. What do you do with the deportation order? Well, one, you can always appeal it to the BIA. Every case is individual, but you can basically appeal the judge's decision. Within 30 days, you have to file your appeal and let the government know that that's what you're doing, right? If you did not appeal, and the reasons can be myriad. You missed the date, you didn't hire the attorney, your attorney said you can't appeal, whatever the case is. You now have a removal order in United States. Depending who is in charge of the administration right now, they can be either actively looking for you, or more so, let's say you're working somewhere and there is a raid, and ICE comes in and they check your prints and your A number, they will see that you have a removal order and you will be taken into custody. Also, if you subsequently, after, let's say it's been 20 years that you've had this removal order and you're now married to a US citizen and you have children together and you want to try and get your green card, you cannot, like other people, just apply for a green card. You have to deal with your removal/deportation order. Those orders do not expire, they do not go away. Once you have one, it stays on your record, and the immigration services, ICE, judge, they can all see it. So, motions to reopen can be filed within 90 days of the deportation order or removal order. I just say deportation Most people are in what's called removal proceedings, but most people know the word deportation better, just more familiar with it. So even though it's a removal order, I'm just gonna say deportation, so it's more clear. It's an order that allows ICE to remove you from United States or deport you from United States. Now, let's say you have the deportation order and the date of it is July 1st, 2021. You have 90 days to file your motion to reopen, with exceptions that I'm gonna go over right now. Motions to reopen must be based on new facts. You cannot go back to the judge and say everything is exactly the same as it was on July 1st, but I just want to reopen my case. That doesn't work. You can file it based on evidence that you did not have at the time of your last hearing. But it cannot be that you simply didn't have enough time to get them, or you forgot to get them, or you didn't know you have to get them. It has to be evidence that were not reasonably available at the time of your last hearing. Another reason to file a motion to reopen is a change in personal circumstances. Let's say, what is a very common thing? Let's say you're from a country, and while you've been in the US, you have become actively involved in a party that is a political opponent to the ruling party in your home country, and you now fear return to your home country because you have been active on social media, or you have been acting in the party, and you can show that that can put you in danger, right? That is a change in personal circumstances. Two, let's say you were removed because of underlying criminal convictions, and after the deportation order, removal order, you have been able to change the convictions in a way that now doesn't make you deportable, or completely get rid of them through pardon, or changes in the law, then that's another way. And the last one, if there has been a change in the immigration law in United States, and you were ordered removed based on one set of laws, and now that it has changed, then you have an opportunity to go forward with another form of relief that wasn't available to you before. You can do the motion to reopen. Another one, big one, is people who are victims of domestic violence here in United States. If you have been a victim of domestic violence at the hands of somebody who's a green card holder or a U.S. citizen, there is another reason that you can file for a motion to reopen. Motions to reopen, when they're filed, if the case was never appealed, then you file it with the immigration court. If the case was appealed and the appeal was denied, then you file it with, or dismissed, you file it with the Board of Immigration Appeals. Please, this is very important. If you have an order of removal and you have filed a motion to reopen, that does not in and of itself prevent ICE from removing you from the United States. If you want your deportation or removal to be stayed, you have to accompany your motion to reopen with a motion to stay deportation or removal. The one exception to that is when you're filing a motion to reopen an in absentia order of removal. In absentia means that you were ordered removed while you were not present in front of the immigration judge. Motions to reopen are structured. They have a certain format. They require evidence. Every evidence is going to be different based on your circumstances. They are very case specific. There's another, motion to reopen that gets filed with the judge. It's called sua sponte. That means when you're asking the judge to open up your removal proceedings on the judge's own accord. The circumstances and your request has to be compelling, right? The judge has to see why you're worthy of the exercise of such decision. If you just go to the judge and you say, hey judge, it's been 20 years, let's see what else can we do, that's not going to work. There are circumstances should be somewhat compelling, and we have been successful, very successful actually, in reopening past deportation cases. Now, the 90 days rule. 90 days is a rule. However, as any rule, in almost any circumstances, the rule has exception. What is the exception? If you ended up with a removal or deportation order due to fraud or deceit, the time between the removal order and time when you're filing a motion to reopen can be told, can be extended. But the fraud and deceit have to be evidenced. There has to be some proof that has taken place, and it has to be reasonable, right? It can be 25 years later, you all of a sudden discovered that, there was some sort of fraud or deceit. That doesn't seem to be reasonable. Of course, every circumstance is different, but the time to which it's going to get extended has to be reasonable. Another one is if there were circumstances that prevented you from filing the motion to reopen within 90 days. The clearest example that comes to mind right now is extended stay in the hospital or some sort of life-threatening illness that made you incapable of filing the motion to reopen within the statutory 90-day period. So those are like the general overview of the motions to reopen and what can be done. Now, what has changed? The change has been that there is now another form of relief that was not available for the last 4 years, and that is called joint motions to reopen. What is that? When you file a motion to reopen, you go to the judge and you present your case to the judge. And if the case is reopened, you then have to move forward with either your original application or another application. But the person who makes the decision is the judge. The difference with a joint motion to reopen is you do not go to the judge initially, you go to the government and you say, hey government, kindly exercise your discretion and allow this person to reopen their removal proceedings so that they can move forward in obtaining such and such status by such and such means. Under the Trump administration, joint motions were summarily denied, and now since May of 2021, at the end of the May, the Biden administration has changed their position to what it used to be before, and actually made it quite liberal, and we're now able to put together these requests to the Department of Homeland Security for them to take a look at the case to see and weigh the positive factors against the negative and to have a person's case reopened. We have a slew of these cases now that we are working on, people who have had very long outstanding deportation orders, some of them 15, 20, sometimes even more years old, now have adult children or now are married to people who have status here in the US, or now have parents who have status here in the US who can reasonably petition for them and give them the ability to become permanent residents. Those requests are very case specific. We will speak to you and we will give you a very case specific list that you should bring to us, and then you will be working with an attorney, putting together the facts, putting together your entire immigration history, and putting your best foot forward in showing the Department of Homeland Security that your case should be reopened and what you're going to do with it once it is reopened. Before I conclude, the note here is that you cannot reopen your deportation case if you have nothing to do after the reopening. You have to show the judge, if you're filing a motion to reopen, or the Department of Homeland Security, if it's a joint motion to reopen, that once your deportation is dealt with, that you have a path forward, something else that you can apply with that will legalize your status here in the US. That is very, very important, because I do have a lot of people coming to me and they're like, oh, I have this order of deportation, and then when I start talking to the person, even if I do succeed in reopening their deportation case, they have nothing further that they can do. There's no avenue for them to move forward. And in that circumstances, filing whether a joint motion to reopen or a motion to reopen is pointless, because they're going to end up in the same circumstances where they have started before. So these are motions to reopen and joint motions to reopen. Like I said, we will be very, very busy with these in the upcoming months and potentially years, as people who have been unable to do things previously are moving forward. I think it really has the potential of helping a lot of people legalize their status here in the US, move on with their lives, and be productive members of society. I will be concluding here today. I wish everybody a great weekend, great Friday followed by a great weekend. Hopefully no rain, only sunshine ahead as we enjoy the prime of the summer. And as always, if you follow us here but you don't have the time at 10 o'clock in the morning to watch this entire video, please go to YouTube, put in Cohen and Tucker PC, and our YouTube channel will come out where you can watch all videos that I have done going back to March. They're labeled. Usually at the top it will say what I have spoken about, so whatever topic you're interested in is going to be easy for you to find and watch, rewatch, put together any list of questions that you have and send it over to us. Thank you as always for tuning in, and I'm so happy to see everybody here, and always happy to see everybody here in my office. Have a great day, everybody. I will see you next Thursday at